Okay, good evening, everybody. We'll call the meeting of the Cromwell Board of Education to order at 5:33. Alessandra, could you do roll call, please?
Mrs. Cantwell?
Not here.
Mr. Flanders?
Here.
Mrs. Pelliver?
Here.
Mrs. Lamberson? Here. Mr. Matrullo?
Here.
Mr. Menendez?
Might be late.
Mrs. Murley? Here. Mrs. Hooks? Here. Mrs. Russ?
Catherine will not be here today. Okay, next item, approval of agenda, additions and deletions and chairs, review of agenda highlights. Oh, Ms. Cantwell's here. So, nothing to change on the agenda. In terms of highlights, the probably largest topic on the agenda will be our training session with our board council, and we will have an executive session at the end. So, if there are no questions, is there a motion to approve the agenda? Motion by John, second by Dipti. Any comments or questions? Hearing none. All in favor? Aye. Opposed? Abstentions? The motion carries unanimously. Okay, next item, correspondence. Are there any correspondence, Dr. Macri?
No, nothing that.
Okay, so no correspondence. Next item, public comments. Before I read the rules for public comment, is there anybody from the public that would like to comment? Okay, so I will read the rules, and then if you could just go to the mic next to Mr. Flanders and give your name, and also just make sure the red button is on the mic. It says push. Okay. We welcome and encourage public comments at our Board of Education meetings. To make sure that our meetings are conducted respectfully while encouraging public participation, following all the rules for public comment, the public comment portions of the meetings. Thank you for your cooperation and participation. Individuals are welcome to address the Board of Education for up to 3 minutes each during the public comment portions of the meeting, but board members will not generally engage in dialogue. The Board of Education chair may, at his or her discretion, extend the time for public comments. Speakers must come to the podium and share your name. To facilitate efficient sharing of your comments, we encourage you to share any comments you may have about instruction, discipline, or learning materials first with your student's teacher, then principal, and followed by the superintendent before bringing the comments to the Board of Education. However, if you do not believe your comments have been addressed appropriately, or if you believe they should be shared with the Board of Education for any other reason, please feel free to do so. All comments must not include personal attacks, and comments cannot be discourteous, threatening, vulgar, or otherwise inappropriate. The board chairperson may, at his or her discretion, curtail any public comments or terminate any such individual's privilege of address at any time if they violate any of these rules, violate reasonable standards of decorum, are boisterous, or are repetitious. The Board of Education reserves the right to limit public comments to particular topics. So, that being said.
Thank you. Good evening. My name is Dr. Ann OBrien, and I wish to speak on the topic of unmasking our children. And I'm sorry, I have this to 3 minutes, but now that I'm doing it through a mask, I'm having a hard time inhaling. So could you bear with me to, it might take a little longer than 3 minutes because of the breathing issue. I am a 20-year resident of Cromwell, and my 2 adult children attended Cromwell Public Schools at all levels. I'm also a licensed pharmacist with a 23-year career as a drug information specialist in skilled nursing facilities. I've been intensively studying all aspects of COVID-19 and the pandemic since the beginning. I review a vast amount of the new information that becomes available every day on the SARS-CoV-2 virus, the shots, as well as the interventional measures being pushed as proposed infection control procedures. I am speaking today to offer you the first hard data that has been published in a peer-reviewed journal, the Journal of the American Medical Association, also known as JAMA, specifically regarding mask wearing in children. I provided the full text of this study to the board. This study demonstrates quantitatively the carbon dioxide content of the air being breathed by children who were wearing 2 different types of masks. These children were breathing CO2 in measurements as high as 25,000 parts per million. You will see that masks put the children as much as 5 times above the 5,000 parts per million standard, as shown in this JAMA study. OSHA typically imposes fines or penalties if these standards are being violated. I ask, why would the violation of these safety standards ever be tolerated for our vulnerable growing children? I know that the current plan for this school district is to mandate mask wearing for our students inside the school buildings this fall. Even if the governor's guidance modifies this order to exempt, say, students who got the COVID shots from wearing masks, it's still critical to become aware of the scientific data, which shows repeatedly that cloth or paper masks do not stop the transmission of viruses to any proven extent. Additionally, I maintain that the wearing of face coverings in fact causes harm to our children, and this article in JAMA that I provided you shows this in its measurements of carbon dioxide that they are breathing all day long. It's time to withdraw the mandate for wearing masks for everyone in the Cromwell Public Schools. It's also time for the elected Board of Education representatives to take back from the state government their right to make decisions locally for our kids. If you say to me, the mask mandate can't be removed without losing federal funds or state funds for our schools, I ask you to search your consciences for the answer to this question. What is more important than the health and well-being of our precious children? Perhaps, as a preliminary step, you could conduct a formal survey of parents and students in Cromwell to see what they think and feel about the mask mandate in schools, and share this JAMA article with everyone. I have provided the board with 6 documents to accompany this statement. I implore you to read all the scientific, published research information in full so that you can take a well-informed approach to removing the mask mandate in the best interest of our children. Thank you for your attention.
Thank you, Dr. Ryan. I did receive another submission to be read for public comment from a parent who could not be here today. So I will read that to you. The comment is from Jessica Tomzak. So she writes, to whom it may concern, I am a mother of 2 children in Cromwell schools. The last year and a half has been a roller coaster for all of us, but none have suffered more than our innocent children, whom are at minimal risk of being affected by this virus. Prior to last March, my children could be found playing with the neighborhood kids, going to school and being carefree as a child should be. Today, they are limited to what they can do, where they can go freely, and as many places still require masks for all. My children will not set foot into any building place where they must wear a mask. For a year and a half, the only place that we have gotten them to go to with one on was school, and that was very begrudgingly. Imagine disliking something so much that you do not want to go play mini golf, visit a museum, aquarium, or your favorite ice cream place. How would that feel? We lost out on so much, but the biggest thing is the memories that were lost. Yes, we could have still gone to many of the places I listed with them, but at what cost? Why would we go knowing that they would be miserable wearing a mask? Then there are the facts of the COVID-19, quote, pandemic. I say pandemic loosely. Did you know the definition of a pandemic was changed in recent years, but that this wouldn't have been a pandemic according to the old definition? Because of the pandemic, we are in a, quote, state of emergency, which provides the state federal funding, which leads me to ask, why is funding being held hostage for our schools, for our children being held hostage? How has this funding been used to improve ventilation in facilities like our schools? Per the CDC, children can be infected, but most children have mild to no symptoms at all. There have been studies indicating that their risk is extremely low. Here is an example of one of them, and there's a link to an article. At this point, adults who wish to have had the opportunity, with about 70% of the state's population having received the COVID shot and more still having antibodies, why would we then say we need them to mitigate risks? Haven't we already protected our most vulnerable? Through April 2020, the official recommendation by the Journal of the American Medical Association was unambiguous. Quote, face masks should not be worn by healthy individuals to protect themselves from acquiring respiratory infection because there is no evidence to suggest that face masks worn by healthy individuals are effective in preventing people from becoming ill. Close quote. Part of that lack of evidence, in fact, showed that cloth face masks actually increase influenza-like illness. In contravention to established science, states, municipalities, and businesses have violated the legal requirements for the promulgation of medical countermeasures during a public health emergency, stating a belief that face masks limit the spread of SARS-CoV-2. CDC guidance was released recommending that the continued use of masks in school-aged children over the age of 2. What data has been used to determine the efficacy for the use of masks prior to requiring them in schools? Initially, there was not much information, but now that there is more, what are you using to determine if masks will continue to be required? Has the increased presence of carbon dioxide been taken into consideration? What will the effects of this presence be? Here is a link to a study on carbon dioxide presence when masks are used. Mask packages themselves have a disclaimer that they do not prevent the spread of virus, so why are we continuing to use them? It is known that the particulates from the virus would require a properly fitted N95 mask to prevent the spread of the virus. Further, masks are considered a medical device. Only medical professionals should be prescribing their use. In fact, the mask requirement could be considered part of a legal clinical trial. 21 Code of Federal Regulations, Section 50.24. Illegal clinical trial, all parties mandating the use of face masks are not only willfully ignoring established science, but are engaging in what amounts to a whole population clinical trial. This conclusion is reached by the fact that face mask use and COVID-19 incidents are being reported in scientific opinion pieces promoted by the United States Centers for Disease Control and Prevention and others, close quote. I would like to also ask what studies have been done that you are using to determine the effects of the following regarding children wearing masks: effects on mental health, development of children, educational impacts, especially for those learning to read it and sound things out, air, oxygen quality. We were asked to slow the spread for 14 days. That's all we needed to do. So we all joined together to mitigate the spread as requested, and yet this carrot keeps getting pulled further and further away. I'm asking that regardless of what you believe, that you allow the wearing of masks to be a choice. Please follow the science, and regardless of the threat of funding, uphold your duty to our children. Thank you, Jessica. And then there was another note from a student. I won't name the student's name, but it says, "Hi, I'm 11 years old, going to 6th grade, and I don't like masks. Paraphrase, I don't like masks because I cannot breathe in them well, and they make me sweaty and uncomfortable. I can't see my friends' faces. My teacher can't always hear me, and sometimes I can't hear her. Please don't make me wear a mask again this year. Thank you." So just wanted to read those into the record as requested. Okay, next item, reports of liaisons from the Town Council and Board of Finance, focus on issues of interest to the school community. So I saw Steve from the Town Council.
Good evening, everyone. Let me just say it's great that to have everybody back together and actually see everybody's faces, whether you're happy to see me or not. So just a quick comment. So the Diversity, Equity, and Inclusion Committee is going to be putting on a wheelchair basketball game, kind of training. So they received a $500 grant in support of the event. The co-chair, Elsie Newcomb, was able to get some support from the Ryan Martins Foundation to get some additional volunteers to run the clinic and also provide equipment for volunteers. So they're trying to shoot for August 7th, which is a Saturday. They're hopeful, Dr. Macri, that they may be able to use one of the gyms, maybe WIS or the middle school. Actually, I think they said the high school, but I don't know with all the construction. But one or the other would be great to do because they're suggesting outside might be more of a challenge with the equipment. So I know Caitlin Perro had reached out to Lynn. I can't think of her Lynn McKenney, but I think she's on vacation this week. That's what I'm being told. So, but hopefully she gets back to her. The committee would love to take volunteers. She's maybe hoping some of the high school basketball team, the girls or boys teams, might want to participate and assist. I think they're attempting to get people into chairs and to show what someone in a wheelchair may experience in trying to play that game. So you might even see me there. So I appreciate it. Thank you.
Thank you, Steve. Any questions for Mr. Fortenbach? No? Okay, thank you. And I don't see Mr. Netto or Mr. Ireland from the Board of Finance, so no Board of Finance update tonight. Okay, next item, presentations and reports of administration, budget update 2020-2021 school year.
Just very little. We do have we have finalists for the AP position for the high school, and I will be interviewing finalists. Oh, I'm sorry.
Did I miss something? Oh, I'm
Response.
sorry. Did I skipped an? I'm sorry.
Oh, and I was
I'm sorry.
here. I'm sorry. I didn't skip
I
it.
skipped an item.
Apparently I didn't listen to you.
No, and I didn't.
I'm sorry.
Sorry. Superintendent's
Sorry.
updates and responses
was-
to BOE comments. So sorry. It is
It's okay.
to you. Sorry about that.
That's just very quickly, just to let you know, we're almost there. And excellent pool of candidates, which was which was wonderful. And unfortunately, I might be bothering you all to have a special meeting so that we can hopefully get the person started as quickly as possible. And then just the other, the Culinary Arts Kitchen, which we are getting built. The asbestos removal is beginning shortly, and hopefully, we don't believe it'll be completely finished, but it'll be safe for students to be in the building. We hope it'll be finished by November, but then we all know that everything in construction is slowing down and it's taking materials a long time. But at least it's getting done, and our students are elated, and more kids are going to get to participate. And then I just wanted to let you know, and I could do this under actually reopening plan update.
Okay, now on to presentations and reports. Oh, sorry, John. Please go ahead.
When we got Mr. Kunkel, we had to wait a month or so before he was able to start prepping his old contract. Are we still going to be, I mean, even if we were to act in August, we would not have somebody on board until, what, October?
As far as the,
Sorry.
it's okay. I know. I know. You mean as far as the,
Well, I think when Mr. Kuckel's
Most of the,
Yeah,
most
30-day
people
notice
have a
period.
30-day.
Oh, yes, yeah.
So we're going to be, so even if we act in August, we're not seeing anybody till October.
no, that was why the final interviews with me will be on Thursday. So like I said, I might be bugging you maybe to come in a little early so that we can get
Oh, okay.
someone on board so that they can give their 30 days if
Okay,
needed.
Okay.
Okay.
That's even better.
Yeah, that's why I said I might bother you. I know everyone's busy, but it'll just help us get going.
Great, thanks, John. Any other questions? Okay, next, presentations and reports of administration, now budget.
Just quickly, Miss Burke is on vacation. She did submit 2 pages to you. We are predicting that we will, we still are obviously paying invoices and receiving items. At this time, we anticipate a small surplus of approximately $3,000 to $5,000. If this should exist, we will go to the Board of Finance, and they have always approved a transfer of the surplus of funds to our capital non-recurring account. Considering the type of year we had where we didn't know if we were coming or going, and the ebbs and flows and the grants that we received, and then we weren't sure we were going to receive, I'm incredibly proud of the business department, and I cannot say enough about Miss Burke. We talked every single solitary day, 2 to 3 times a day, about where we were. Luckily, I'm very happy. We of course we went without. We had to, but we were fiscally responsible and stayed within our means.
Excellent.
Okay.
I echo those words, so congratulations and thank you,
Thank
for,
you.
for all the hard work. Just a question or comment going forward, as we get American Relief Fund funds, can we add a similar chart like we did this past year to show how those are being allocated or will be allocated?
We could do ESSER and American Relief. Yep,
Thank you.
we have it already.
Perfect. Any other questions? Selena?
Just a quick one. At the bottom, it does say CRF grant reimbursement, so that I assume that's part of the grant that we received, and that is put into this
Yeah,
current
that's how we
budget?
made it.
Okay.
Last year.
For last year's budget, we received, what was it, 400 and?
493, 996.
Yeah,
Yep.
we received that money. It was an interesting situation. The state asked us to do a survey. We didn't know, no one knew, that the state was actually going to take that survey and use it as, and actually, it wasn't truly a survey. It was how much money do you need? Cromwell didn't qualify. We're too wealthy of a town to qualify for, there were 3 different areas, one of them being staffing. So we had to pay for the extra staffing, which was close to $600,000 for the year. But we did receive $493 in maintenance, extra support OT, and to help us with, to improve our air quality. You know how we did all of our buildings, air conditioning. Our MERV is like an outpatient center in all the buildings, and for PPE. So we put that, we were able to put, well, we had to put it towards making sure that, you know, had we not gotten that money, we would have been in the red and had to go to the town.
Thank you.
Sure.
Any other questions? Okay. So I assume we'll get a final update maybe next month on the final close of the books?
Yes.
Okay. Okay. All right, on to new business. Item A, reopening plan update. Dr. Macri.
So it's very, unfortunately, quick and short. I was meeting 2 to 3 times a week with either DPH and CSDE, the Connecticut State Department of Education, and Department of Public Health, anywhere between 1 and 3 times a week. For the entire school year. They stopped having the meetings the second or third week of June. They said we were going to reconvene this morning. I was exceptionally excited, and they canceled the meeting. So we do not have any guidelines or anything as of now. The guidelines are what they were when we ended the school year. So just to let you know, the reopening plan was slightly updated, but we're still following all of the rules that were in progress when we left the school year. And it had to be posted online and submitted in order for us to apply for the American Rescue Plan grant. So will it change? Is it a fluid document? Absolutely. Will it change? I have absolutely no idea. Is it going to be a local decision? Is it going to be Governor Lamont who makes the decision as far as mitigation strategies? Is it going to be local? To be quite frank with you, I have absolutely no idea. A lot of people have speculated, but there is nothing that has come. I hope next meeting, which is July 20th, my hope is that doesn't get canceled because superintendents are very eager to learn about what they need to do in their school districts and put a plan in place. But as of today, nothing has changed or been updated, even though the CDC has made a recommendation. Nothing from Connecticut.
Thank you. Any questions? Okay. Thank you. Next, action approval of the minutes and motions from the special meeting on June 8th. That is reference B in your packet. Is there a motion to approve? Motion by Lori. Is there a second? Second by Jen. Any comments or questions? Hearing none. All in favor? Aye. Opposed? Abstentions? The motion carries unanimously. Okay, next, the action approval of the minutes and motions from the regular meeting on June 8th, 2021, reference C. Is there a motion to approve? Motion by Dipty, second by John. Comments or questions? Hearing none. All in favor? Aye. Opposed? Abstentions? The motion carries unanimously. Okay, next, item D, action approval of the minutes and motions of the special meeting on June 15th, 2021, reference D. Is there a motion to approve? Motion by Lori, is there a second? Second by Jen, comments or questions? Hearing none, all in favor? Aye. Opposed? Abstentions? Selena and Lindsay. Otherwise, the motion carries unanimously. Okay, informational principal reports attached as references E, F, and G, and I believe there was one that was sent by email later after the fact?
Yes, the school secretaries were on vacation, so it got submitted just a little bit later, and you all received it by email.
Hey.
And I do have it if you want me to pass it around. Okay.
Any comments, questions? Okay. Okay, next, review roles and responsibilities of board members, Attorney Ritter, Shipman, and Goodwin. So, by way of introduction, we'll have a training session today. We haven't had one in some time, and part of that was because the past couple years have been crazy. So we'd like to invite Jessica Ritter, our outside counsel, to do a training focusing on, if we have power, Did you step on something, Steve? It's very fortuitous. The laptop is on, but... Oh, here we go. We're back up and running.
Nothing surprises me anymore.
So are we still live, Rob, or we're still going? Okay. So for those in watching remotely, we just had a power outage, but something seemed to be on. So, again, training that's probably long overdue, but I invite Jessica Ritter up to give us a training seminar on tips to become a more informed board member. So this is a fairly open session. Feel free to ask questions at any point in time. Thank you.
Texting Tommy to see if he could.
Okay.
This isn't commentary, it's just so I can see.
John, I fully expect to be heckled by you. It's okay.
And just, do you want to grab a seat with the microphone, or? is-
Here, Jess, you can have mine.
Actually,
I was going to use I need to use the slide advancer. I can move to that. No, I can
Yeah,
go,
this
I can
just-
go over to the podium if that works for you.
let's try to have, yeah, the podium works fine because there's a microphone there, so that's good.
Okay, or Jess, you can have this seat and I can advance for you. Just tell me when to.
So I don't know if everyone's met Jess before, because it's been some time since we've been
almost everyone,
in person,
yeah.
so. Jessica Ritter?
Sure, yeah, absolutely.
Have you met Jessica? Okay, okay.
Oh, no, I don't need to sit.
I have to tell you that not giving me the materials is a good start.
John, I'm sorry. You know, John, you moved, you threw me off. I'm going to heckle you back, John.
So everyone over here just left, does that mean I missed the part where we get to make comments today?
Yes. Sorry about that.
So pretty much,
Dealing with you guys
are we
today,
stay with,
Yeah, sorry, that was the beginning of the meeting, sorry.
it's the 6-month-old puppy, it's like having a new kid, I swear to God.
Can you move this up to that and just let her do the final one?
Oh,
That's from board members.
That's right.
If you would like to submit something in writing to Dr. Macri, she can distribute it to the board if you would like.
I'll come back.
Okay,
What was it? July?
that's not our meeting. Our meeting is August 10th, I believe. The second Tuesday in August. If everyone's okay with it.
I think
Okay.
we amend the agenda to allow.
That's fine. That's fine. Okay, did you hear me do the rules for public comment?
Oh, I didn't.
All right.
Well, then that's it, I'm out then.
Okay, if I could just read the rules for public comment one more time. Sorry to, if you would indulge me. Okay, we welcome and encourage public comments at our Board of Education meetings. To make sure that our meetings are conducted respectfully while encouraging public participation, following are the rules for the public comment portion of our meetings. Thank you for your cooperation and participation. Individuals are welcome to address the Board of Education for up to 3 minutes each during the public comment portions of the meeting, but board members will not generally engage in dialogue. The Board of Education chair may, at his/her discretion, extend the time for public comments. Speakers must come to the podium and share your name right next to Mr. Flanders' seat there. To facilitate efficient sharing of your comments, we encourage you to share any comments you may have about instruction, discipline, or learning materials first with your student's teacher, then principal, and followed by the superintendent before bringing the comments to the Board of Education. However, if you do not believe your comments have been addressed appropriately, or if you believe they should be shared with the Board of Education for any other reason, please feel free to do so. All comments must not include personal attacks, and comments cannot be discourteous, threatening, vulgar, or otherwise inappropriate. The board chairperson may, at his or her discretion, curtail any public comments or terminate any such individual's privilege of address at any time if they violate any of these rules, violate reasonable standards of decorum, are boisterous, or are repetitious. The Board of Education reserves the right to limit public comments to particular topics. So, with that being said, if you wouldn't mind coming to the podium and just give your name,
Sorry about that.
just make sure the red light on the mic is on, if you could.
Right. Well, I've never been to a Board of Ed meeting. Yeah, my son is a sophomore here.
Sorry, could you just point the mic to your, and make sure the light is on, just because we're
It's
live streaming.
on.
Okay, perfect. If you
How's
could just
that?
start with your name, that would be great.
Jillian Wiley. So
Thank
my
you.
son is a sophomore here at the high school. And I just came out of concerns of the mask mandate. So I know, we just heard superintendent, am I right? Okay. Say that basically it's out of your hands at this point. So I still would like to just make my opinion and that of many people that I've spoke with is that we don't feel it's necessary given how many people have been vaccinated and have gotten natural immunity from getting COVID. So there's so many different opinions, and I wish we could all just agree on the science. Unfortunately, somehow this has turned into a big argument, and no matter which side you're on, it seems like you could find evidence to back that up. So with that being said, I think, if we all just could kind of agree that we could, as parents, do what we think is best for our children. So I'm a nurse. I'm a registered nurse here in Connecticut. I've taken care of COVID patients. I've seen firsthand how bad it can be. I also don't think my son needs to wear a mask. I don't think any of the kids need to wear a mask. I think if you want your child to wear a mask, or if you want to wear a mask, I absolutely think that that's fine for you. I do know that there are plenty of scientific studies. Again, I'm not going to sit here and read them to you, and I have them. They're not, Fox News studies. This is, which by the way I do watch, but it's NIH, it's the CDC, it's WHO, it's the Department of Public Health, which I get information from all the time. So there's risk for hypercapnia, there's risk for hypoxia, which basically just means you're rebreathing the carbon dioxide and not getting enough oxygen. Which kind of feel like everybody might know what COPD is. And a lot of people suffer from that. I take care of a lot of people with COPD. And part of that, it kind of is like we're inducing that in our kids. So they get brain fog, they get very tired, they get headaches. And although not everyone might experience this all the time, it does happen. And we don't know long-term effects of these things on our kids versus, again, let's not go into the numbers, but the risk of COVID is so minor to kids. It really is. And even with the new variant, it's still very minor. So I hope most teachers have been vaccinated, and I just don't think it's necessary. And I just really want that on the record because I feel very strongly about it. I think that we're risking too much. It's even just the facial expressions. It's nice to see people here and their smiles, and we're losing a lot without having that. So I think that's about it. I mean, again, if you want your kid to wear a mask, wear them. I didn't go into how, they're really not effective as far as aerosolized and surgical masks versus N95s. I went into, people who had COVID, I have to be fit tested for an N95. So what happens with the fit testing is you put the N95 mask on. I try a bunch of different ones. They put you in this weird thing. You look like a little NASA guy. And they spray this stuff and you have to see if you taste it, smell it. And if you do, it means the N95 doesn't work. If you had a surgical mask on, you would instantly taste and smell those things. And that's how we test for airborne illnesses. And this particulate for the COVID is very small. So, meaning that it's like micrometers, and it's less than the standard droplet precautions, which gets into stuff that I'm super aware of being a nurse, but you might not be. But, I'm pretty trustworthy. So I'd say maybe it'll help, maybe it won't. But bottom line is, I don't think they should wear it. I think there's more harm than good. So that's that. That's
Great.
about it.
Thank
And no, I don't want to vaccinate him. Don't get me started on that one. I've been vaccinated, but I don't want to vaccinate my child. I also think that that's unnecessary. So I just think that they should be able to be kids and let the grown-ups take the risks on unauthorized vaccines, and the risk for him getting these things that are popping up, getting the vaccine, is far less, again, with risk versus benefit. It's far less than it would be if he got COVID. If he got COVID, he'd be fine. I really think he'd be fine. Every patient I have had that had COVID that was of normal age, my age, your age, it was fine. People I work with, fine. I have had patients die from it. They also were in their 90s and had COPD, diabetes, congestive heart failure, etc. I've also seen a lot of patients that had all of those things survive perfectly fine. So, so I want to send him to school and let him learn and let him see, You know, it's high school. He's got to see the pretty girls' smiles, right? And have him have a good high school experience. Freshman year was crazy, and I want to be able to come into school and just live a normal life. I think this has gone too far. Let the grown-ups deal. We'll get vaccinated. We'll wear masks. We'll do whatever we have to do to make our kids be just normal, everyday stuff. Okay, so that's my opinion. Sticking to it.
Thank you, and thank you for
Jillian Wiley, over and
indulging
out.
us. Thank you.
I'll-
Great, thank you. And feel free to stay and, no problem. Thank you. Okay, Jess, over to you.
So you want me to use the microphone?
If you don't mind, just so people streaming can hear.
Walk around, but I will.
Is the a red light on? Yeah, just,
Is that good?
yes, perfect, thank you.
Okay. Can I move this so I can
Yes,
see the?
absolutely.
All right. Thank you. Okay, hi everyone. How are you? I think that I have actually worked, even with all the new board members in here, I have worked on you even though it's been remotely, but it is nice to see you in person. So I'm here today to talk about practical tips on how to become a more informed board member. About 4 or 5 slides in, John, who will be heckling me the whole time, I know that, did catch a grammatical error, which I do apologize for. When we get there, I'll point it out. But my sincere apologies, because it's an embarrassing error, so I'm sorry about that. But we'll get there. What you have in front of you are the responders. For those of you who I think maybe a few years ago were here for a similar type presentation, I like to keep this interactive, have it be a dialogue. Feel free to stop me and ask any questions, because really this is your training. So, I mean, I can talk up here for hours about all of this stuff, but I want to know specifically what your concerns are in Cromwell and what the interplay is between our Board of Education and our Superintendent of Schools. So feel free to stop me at any time. You'll see that I've built in a number of scenarios into the presentation, which is why you have the responders. It does collect data, but it is anonymous data. But I hope that everyone will share their thoughts on the scenarios. Jeff, tell me about timing, because I can work around your timing. You want to go for an hour?
I think between an hour, hour and a half, anywhere in there, leave the time for questions. But,
Okay.
you know, our summer meetings usually are shorter meetings, so.
Absolutely. So I'll plan for an hour, and I'll cover what I think is probably the most important.
Okay.
And again, that's why I provide you with the materials, because there's a lot of things in there that will still be helpful to you even if we don't get to
And
it.
if anybody has questions or wants to go longer, then we can certainly do that too.
Okay, so here's our agenda. We're going to talk about your roles and responsibilities, which I understand is really what we might be emphasizing this evening. There's also board meeting essentials. We'll talk about board member conduct, the executive session, the privilege of executive session, which is probably, as Attorney Flanders probably knows, the most violated provision of the Freedom of Information Law is the executive session. We'll talk about electronic communications if we get there, and what you as Board of Education members need to be mindful of when you are communicating via email, via text, anything that is electronic. How to conduct a meeting, public comment, and then just some best practices. Again, we won't get to all of this, but this is what's built into the presentation. Okay, so here is I just want to point out in the third bullet, I very much apologize, Enza. That should say, who serves as the Chief Executive Officer. I am going to blame my marketing team, because they're the ones who put this together after I am the brain behind it. They have to execute the marketing.
I love you.
I know, so I am very sorry for that.
I'm positive that if my family is watching and my friends, they're loving this.
Yes. So that should be who. So I very much apologize for that.
I'm coming back to the next one.
Right, I know. So again, my sincere apologies for that. Okay, so you are a Board of Education. What I just passed out to you are 2 relevant bylaws that I think is very important for you to understand, right? So we have your limits of authority and we have your board-related responsibilities. So if I'm looking at Board Bylaw 9040, you can see that these are your bylaws that you, the Cromwell Board of Education, have adopted. You can see what your responsibilities are, and that right now it's limited to 6 provisions. So 1 is to employ an able and qualified superintendent of schools. That's probably your most important responsibility. So as you know, the superintendent of schools through 10-157 serves as your CEO. So she is responsible for the day-to-day, the operational. She's responsible for implementing policy that the Board of Education determines is either legally necessary or necessary to meet the needs of Cromwell and its community and its students. She then takes those overarching broad policies and implements the administrative regulations. Because you as Board of Education members, you're not here every day, and you should not be getting down into the weeds of the everyday implementation of your policy. We need to trust in our CEO and give her that discretion. She is also the only employee that you have. So let's say you have concerns with an administrator. That's really not for you to opine on. That is for your superintendent of schools to deal with. Let's say you don't like the way your superintendent of schools dealt with a certain issue with an administrator or a few administrators. That's something you take up with your superintendent through her evaluation process. But that doesn't mean that you as Board of Education members get involved or into the weeds on an employment situation with any administrators or anyone below the ranking of the superintendent of schools. Now, as you know, you have a legal obligation to evaluate the superintendent of schools once annually. Now, is that something that has been done diligently? Okay. So as you know, now do you normally do it as written feedback or verbal feedback?
We usually do both. We provide written, we do a written evaluation, which the board votes on, and it gets presented to the superintendent. And in the context of that delivery, there's verbal feedback discussion of the written evaluation.
And that's also a statutory obligation. There's a statutory obligation that you as a Board of Education annually evaluate your superintendent of schools. The other thing that you have, so if you're looking at 90-40, you adopt policies that govern the operations of the school system. You are absolutely the policymaker for the school district. But again, there's a difference between making policy and implementing those policies and the administrative regulations associated with those policies on a day-to-day basis. Now, do you have a policy committee here, I'm assuming? And what's your standard process for anyone who's on the policy committee? What's your standard process with respect to policies?
In terms of adopting them?
In terms of adopting them, revising them, revoking them.
So we usually have a two-step process where the policy comes to the committee as draft for a first review, solicit feedback, comments, incorporate them, and it comes back to the policy committee for a second read. And then, assuming it's approved by the committee at that meeting, that second review, then it goes to the full board for review.
Okay. And then are you using CABE's policies currently? Ish. Okay.
Because we go back and forth.
Because part of the policy issue too is, now I know that you have several lawyers and you're all very sophisticated board members, but part of the issue too is with policies is there are several that will be identified as you absolutely legally have to have this policy in place. So like our DCF, child abuse and neglect reporting procedures. There's not much wiggle room for you as Board of Education members to to have any variations off of that policy, because that's going to be strictly legal. You are essentially regurgitating the statute in a policy like that. So that would be going above and beyond your authority if you said, well, I want to revise this accordingly, because we want to make very sure to protect the district and to protect our administrators that that policy is up to date every year and that all of our administrators and all of our staff understand what the protocols and procedures are. Now, you might have a valedictorian or a grading policy where you do have more discretion as Board of Education members to decide what you want that to look like. And so you just have to keep in mind that even though you are policymakers, there are some policies in which you really don't have much choice or much jurisdiction over. The other thing it talks about is communicate the educational program to the people of the community and serve as a communication link between the community and the school. So that's certainly true, right? I'm sure that you all got involved because you either have students in the school district or you're very passionate about educational issues. And so certainly you have constituents that you have to report to. So that certainly means that you can have communications, you can have dialogues with constituents, but we have to be very careful about what we are discussing with them. Because there are certain things that are absolutely, even though you are a Board of Education member, not within your purview, and it's not appropriate for us to be having those discussions with people in the community. So for instance, if someone came up to you and said, I don't like teacher X, Y, and Z, it doesn't mean that you can't forward that concern to the superintendent of schools, but you cannot opine or issue an opinion on how you also feel about that teacher. You have to be really careful. Now, I know some of you might say, well, as a parent, I might have had that teacher and have very similar feelings. You have to be mindful about your role. It doesn't mean that you sacrifice your rights as a parent, but you just have to be mindful about not blurring those issues. You also have to be mindful that anything related to a teaching issue might come before you after our CEO and our administration has properly dealt with it, and you might have to serve as judge and jury, and we'll talk a little bit about that. If you've already been involved or you've tried to micromanage something like that, that's going to be extremely problematic and potentially expose the district to liability down the road. So we have to be very careful about how involved we're getting in things that are strictly administrative issues. Number 4, keep abreast of future educational needs of the town as well as the present, which you all do, right? You're all very well informed. The superintendent keeps you well informed about what's going on in the community. You adopt an annual budget. So that's probably, other than the policymaker, the most important thing you do. And as you know, you're a separate statutory entity from the town. Your greatest autonomy is your ability to spend your appropriation in the way that you determine to be appropriate. So I would say the policymaking issues and the budget, where you, after listening to your community, after, knowing what the pulse is in this community, you earmark and determine where you should be spending things. Of course, you do that in collaboration with your superintendent of schools, because again, she's there for the day-to-day, right? She is the expert of what's going on in Cromwell. She's going to make a recommendation to you about what you should be spending your appropriation on, but then ultimately it's up to you to approve that budget. Lastly, it says, take such specific actions as are required by law. So that's pretty open-ended. But I think the takeaway from here is your responsibilities are somewhat limited, right? And so I think we just want to understand that you are a Board of Education member, you are an important part of the community, but you don't have, other than here in a board meeting, you really don't have any greater access or greater privilege to information than the average citizen off the street. And so those are some other things that we're going to talk about. And so we need to be mindful about those things. Okay. So for instance, you do have an obligation to preserve confidentiality. Now, let's say that there is a pending student issue that has to do with a parent in the community. You don't have a right to know what's going on with that student and that family unless they give explicit consent for the Board of Education to know, or unless it has come before you through a disciplinary proceeding or a transportation proceeding, or maybe there's a pending litigation where it's appropriate for you to have an executive session so that you can authorize the superintendent of schools to settle a very expensive legal action. Other than that, you don't have the right to that information. So I actually went to the Freedom of Information Commission with a board member from another district, 5 or 6 years ago, where he demanded to know everything about a student situation because it impacted his brother. And he demanded to know everything and took us all the way to the commission when we denied it because he said, I'm the board chair. I should have this information. I should know all about it. And we took the position that this was not within your purview. This was an incident that was not being brought before the Board of Education. It was not a disciplinary proceeding. It was not a transportation proceeding. It was not a pending litigation. And under FERPA, you don't have any greater right to those records unless we have explicit consent or it falls under one of the exceptions that I talked about. When you do actually have access to that information, like I said, and it may be appropriate in a an expulsion proceeding, you cannot share the information that you acquire in your role with anyone outside of that room. So that's very important, right? Because anything that you're receiving in a disciplinary proceeding or transportation proceeding, you have an obligation to preserve that confidentiality. And if you don't, there is exposure for the district. So the family could file a FERPA claim. You could have FEPCO, the federal agency who enforces FERPA, come in and do a full-blown investigation, and you're going to incur costs. Okay. So we talked a little bit about that. So now let me just talk about the teacher tenure hearings too. So we talked about expulsion, school accommodation, transportation hearings. That would mean that you as board members would have a legitimate need to know that information about the students, because in order for you to do your job, sit as judge and jury in expulsion hearing, you would need that information. But that's a limitation under FERPA. A teacher tenure hearing, so let's go back to the teacher that I was talking about. You're stopped in the grocery store, Lori, and someone says, I don't like teacher X, Y, and Z. I think teacher X, Y, and Z should be fired. Well, the superintendent of schools, for all you know, might be working on a case in which she is going to come to the Board of Education to recommend termination. Your superintendent, even though she's the CEO, does not have the legal authority to fire a teacher. The only person who can terminate a teacher or administrator or anyone operating with a teaching certificate is the Board of Education, which is why it's so important that we don't get involved in the details until it appropriately comes before you. So, ENZA's going to make those decisions. We trust in ENZA that she's going to do the right thing. She's going to make a recommendation that the teacher be terminated in accordance with 10-151. That teacher gets to challenge that recommendation before an arbitrator. An arbitrator makes a findings of fact and conclusions of law, which is not binding on the Board of Education. That arbitration opinion comes to the Board of Education. You can decide, even if the arbitrator said there's grounds to terminate this teacher, you can decide that there isn't, as long as your decision is based on that opinion and not arbitrary and capricious. So you actually do have the final say on that. Even more important, why we don't get into the weeds before that process plays itself out.
And that's the case even though, as you said earlier, the only employee that the board has is the superintendent. So we have that authority even though technically that teacher's not an employee of the board?
Correct. So it's all based in statute. But only ENZA has the right to make the recommendation for termination. So you Board of Education members don't have the right to say, I'm very upset with this teacher. I don't like how she's been treating these students. I want her fired, or I'm going to get her fired. It first has to be a recommendation from our superintendent and then go through that entire arbitration process before we even get there. Now, I've seen cases where Board of Education members have gotten overly involved in those types of situations, and then the teacher has grounds to say, well, I can't really get a fair hearing, or I can't really get a fair assessment of my case because I know 3 or 4 of the board members have been very involved, have been promoting this action, and guess what? I just FOIA'd all of their correspondences over the last year, and all of their electronic communications make it clear that they've had it out for me, even though they're not supposed to be involved. And I've had that happen too. So I'm just saying these are things where, again, we have to trust in our administration, we have to understand our role, and we have to respect the dynamics between the board and the superintendent. So we talked about that. Okay, so let's do a scenario, and when we get to the next slide, we can use our clickers. So yesterday, the local newspaper published a front page story about a teacher employed by the district who was arrested for running a meth lab. The article identifies the teacher by name and school. Parents from that school come to the next board meeting, and during public comment, several of them address the board to express concern that this teacher must be fired immediately. A 4th parent who comes up to speak attacks the board for sitting there silently like bumps on a log and asks the board members what they're going to do about this bad teacher. Okay, so the question is, can a board member reassure the public that the board will fire this teacher if he is guilty as charged? Is there a poll thing that's showing up on that? In the right-hand corner, there's a little green light. Okay, perfect. So if everyone, so yes or no, if you use your clickers, if you try to point it at the computer, try to point it at the computer, and then once you guys know that, let me know if you voted. Okay, go ahead, Lori. You voted 3 times, so you're skewing the data, John. All right, let's see. Okay. All right, so 86% went with no. Oh, I closed the poll, Lori. Lori, I closed the poll, but you can, what's your answer, Lori? So you think that we can reassure the public? No. Well, we're going to go with no. Okay. All right. What does everyone else think? No. Right. What is an appropriate thing to say? Should we say anything at all? Do we engage during public comment?
You don't have to, but you could say that, well, can you, I guess, I should say. Can you say, once we have information, we'll be sure to notify everybody?
You can't really say that because you actually don't have the right to notify everyone of that information. So if particularly, let's say, teacher's evaluation, any kind of evaluation materials are specifically excluded from disclosure under state law, unless we have specific consent from the teacher. Now, this is disciplinary in nature, but again, the Board of Education, if you're making comments at a public meeting that I'm going to get back to you on that, that's potentially problematic given the whole process, the statutory process that I just laid out. Not to mention, a lot of these things get resolved before they even come to you. So you have to trust in your administration that she's going to resolve this, negotiate some type of separation agreement with this teacher, because the problem is the law is stacked against you in that if you move to termination, you have to pay the employee during the pendency of all the proceedings and keep them whole, and the proceedings can take 6 months. So sometimes you're better off from a cost-benefit standpoint to negotiate some type of settlement agreement to get them to leave sooner, not incur all the costs, the legal costs and everything like that associated with it. At that point, I would still not want the Board of Education to ever comment on that, though the actual settlement agreement would be a public document if it were FOI'd. In this situation, so let's say this happens, again, you're you would have the right after the fact to, through an attorney-client communication, which would probably be the only appropriate way to do it, to have ENZA fill you in on some of the details. Not all of them, but just so that you can be reassured that it was handled, that the teacher's no longer there, and you don't have to worry about that. But the comment at a board meeting that we've resolved this issue with the teacher should never be happening here. If anything, ENZA is going to negotiate what that teacher's resignation letter looks like, or she's just going to send, a communication to the parents who may be impacted to say so-and-so no longer works here, and we welcome so-and-so to fill in for that individual.
Unbelievably, in my past experience, something very similar. The board ended up being so involved for like a 3-year period that it really, to not inform you, to tell you as little as possible, ended up being the best way to handle that. As crazy as this scenario sounds, something very similar I have been involved with. So the board ended up having to go through the entire process and learn a lot about the situation because the person wanted the board to, not because I wanted to. So it just protected the board by us keeping it as confidential as possible and addressing it ahead of time, because it could get away from you really fast.
Right. So again, just know and trust in your CEO that you're going to get the information that you need and that is relevant for you as board members. And as frustrating as it is, Lindsay, because I know you want to be able to say to your constituents, your friends in the audience, right, parents that you're probably friends with.
We're listening in that, we're taking your, or, even that ends of listening, in that take your opinion seriously and stuff like that. But I know I don't ever say anything because I don't know what's, you know what I mean, in these situations when you make public comment. But I feel sometimes bad that it's just like nobody says anything.
Or you could say, yeah, or you could say either, thank you, like Jeff said, thank you for your comment today. Jillian, is that right? For Jillian's comment today. Or you can also say, someone stops you in the grocery store, thank you very much. The appropriate person to go to would be the superintendent of schools to address that situation. Okay, here's another scenario. Board members Facebook friends with a teacher. Oh, I'm sorry, Lori.
I'm not sure how you are. What if the problem, the complaint is about the superintendent?
Yeah, so we've
Never run into.
never run into
We know nothing about those scenarios.
So, if you remember, Lori, one of the reasons that you established an HR department is because a few years ago you didn't have an HR department, right? So, if there is a complaint about the superintendent of schools, we'd send it to the HR director. The HR director would, or the board chair. The board chair is likely going to call legal counsel to address next steps. But that is exactly why this board, you contemplated this exact scenario. You were missing that avenue. And that has been Michelle's charge, that there is a place, and not specifically to the superintendent, but that there is a place where people feel comfortable saying, I'm having this personnel or employment issue. And that would be the first start.
I just asked that question because of what we went through in the past. Just so everybody knew what to do in case.
Absolutely. Absolutely. And actually what really happened there is once it got to your former chair, then the former chair brought us in and we sort of, because the Board of Education can't investigate, right? You don't have the ability to go and investigate that situation. You have to bring in, if we're talking about someone high up, you have to bring in an outside person to investigate that. Oh, yep. Okay, scenario 2. A board member's Facebook friends with a teacher. In a post on her Facebook page, the teacher complains that her principal unfairly denied her 3 days of personal leave to attend nature's classroom in a neighboring school district to serve as a chaperone for her 5th grade son. The board member calls the principal to find out what the problem is. The teacher files a grievance, which is denied at the lower steps and is now before the board. So here's the question. Can the board member participate in the grievance hearing, or does the board member have a conflict of interest preventing him from participating?
So the question is, what's the question?
Okay. The question is, should the board member participate in this grievance hearing? Okay. So I would say that I would have a concern, again, in our scenario, if we go back, you have a board member who is calling the principal to find out a problem about one of their friends who's a teacher. Why is that a problem? You're absolutely overstepping your boundaries, right? Because whose authority is it to discipline this teacher? It's the principal, and then ultimately to suspend a teacher, that has to come from the superintendent of schools. So that's ultimately her venue, her jurisdiction. If the teacher appeals that, it then comes to you and you serve as judge and jury. If, here I know that this teacher, this board member was trying to support the teacher, so the union may not have the same argument to say, well, we have tainted board members. But if it were the opposite and you took the position of this teacher should have been, disciplined more than 3 days, they should have been fired, the union can make a claim that, again, they're not going to have an opportunity to have a fair assessment from the Board of Education. So we really need to be careful about that. The other thing too is I've seen the scenario where, now remember, your Board of Education members, right? Technically, your superintendent of schools is the chief, but you have to understand the influence that your role has. And so if I'm a principal and I get a call from a board member, that's pretty intimidating to me. And so I may view that as, well, maybe I shouldn't do this. Maybe I should undo this. And now you're really unduly interfering with maybe something that's perfectly appropriate for this teacher to have this level of discipline. Because we also have to make sure that there's consistency in application of employee matters, which only our superintendent of schools is really going to have that type of knowledge. But I know it's very difficult to be a board member. For those of you who are parents, you don't shed your First Amendment rights. You don't shed your ability to be a parent. You don't shed your ability to be an advocate for your child. But you always have to keep in mind that people view you as a board member, even if you are sitting there as a parent, right? That's a lot of influence and power that to that principle you have. So I think, again, you have to remember that it might be lost on you because you're sort of used to this role, but how it is perceived by others. Now, I've also had a scenario where a board member does call an administrator. And remember, all of our administrators are unionized. They're all part of a collective bargaining agreement. If they view this as somehow you are unduly interfering with their operations or you're threatening them in a way, they can file a charge against you. Right? So and I've seen those things happen where a Board of Education member stepped too far, berated administrators in a public meeting, and they all collectively organized and filed a charge against that Board of Education member. Then you, as the board, have to, because you can't investigate your own board member's conduct, you have to authorize an outside investigation to look into the conduct of your board member, because you have to protect yourself from liability. You can't just be deliberately indifferent and turn your head to a serious complaint. And again, we were able to work that out, but you still incur so much unnecessary expense to work those types of things out. It ruins the tenor of the relationship, right? And then you want to spend your time and your energy on our students, not on things like this. Now, you should know that all these scenarios are actually things that have happened. They're slightly revised, but these are not just, I made these up out of thin air. These are all based on real scenarios. Yeah, of course.
Based on what you're talking about with who you contact with questions, I've found that sometimes when I have a question that's specific to a school, I've always wondered, is it better to contact that principal I'm talking about as a parent, although I'm a board member as well, but then a lot of times it ends up going to the superintendent anyway. So what is the correct avenue to take if it's going to
So if it's you as a parent, Selena, right? So if you as a parent are saying, I feel that my child was treated unfairly because he got a lunch detention. You as the parent, the appropriate protocol, I assume in Cromwell, would be that you go to the building principal and you make it very clear. I'm contacting you as a parent, right? Parent of my son, these are my concerns. We don't ever mention the board in that email because I've had that happen too. And I've had ethics complaints brought against board members when they use their role to influence situations at the school level for their students or for their children. So we have to be very careful about not blurring those lines. That being said, though, you have every right as a parent to say, I don't think that my son was treated fairly, and I want to talk to the principal about it. Don't do what I had happen in another district, though, where then the parent goes into that meeting, tells the principal how appalled she is from his behavior and his actions, and that she's going to make sure that all the Board of Education members know about how poorly he handled the situation. Right? So that was a nightmare. That, Board of Education member, there was an unfair labor practice filed, and there was also a pending ethics complaint that eventually didn't go anywhere, but it's still really embarrassing for the community. It's embarrassing for that member. It's problematic for the principal because now, You have a principal who, doesn't feel welcomed in the community. So it leads to a lot of issues. Okay, so we can talk a little bit about board meeting essentials. This is probably stuff that you have a pretty good handle on. But I mean, do you want me to talk a little bit about FOIA? You do? Okay. Okay. All right, so FOIA. What is FOIA? Attorney Flanders, what is FOIA?
Freedom of Information Act.
There you go, Jillian.
You can see my lips move.
Right. I'm impressed, Jillian. What does that mean, Jillian?
And you have the right to request information if it's relevant to a situation, like you said with the Board of Ed members. So if person A, I know no one's names, but if they were talking about somebody, they could say, well, let's show their emails, and then we'll decide if they already were saying, this teacher is blah, 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 and blah, 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 and my son said this, and my son said this, and my friend said this, and this was on Facebook, and da, 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 da. And then they're in front of the board who's supposed to make a judgment call, and how are they when they're clearly biased against that teacher?
Exactly. Okay.
I'm an honorary member.
You are. I love it. So,
Also, I voted B both times. Right, too, just saying.
okay. So you are a public, yeah, she needs a clicker. You want a clicker? You are a public entity. That means that pretty much any document you receive or you create is subject to disclosure unless there is a narrow exception. So that's why I always say to all of our administrators, all of our teachers, and all of our Board of Education members, don't put it in writing if you wouldn't want someone to see it, right? Or maybe just pick up the phone or maybe walk down the hall, right? I mean, we always say this to our administrators. So here's the definition of a meeting too. Any hearing or other proceeding of a public agency, any convening or assembly of a quorum, and any communication by or to a quorum, whether it's to discuss a matter that you have jurisdiction or power over. So that means if Lindsay texts 5 of you and you all start to reply to that, that's an illegal meeting because you have not properly posted and notified a meeting and there has been an exchange of dialogue. Let's say if Lindsay says, I think we should vote for, Jeff as board chair, and you go back and forth on that. That's something within your purview that you have jurisdiction over. It's Board of Education business. You've now held an illegal meeting to discuss whether you're all going to support Jeff for board chair. Yeah.
I just want to know, let's say Lindsay sends 5 board members, and it's about going outside for lunch or something. That's not considered a meeting.
Not board business. That's social. Now, however, and I hate to be... No, but listen.
She does it all the time.
It's totally fine. But if you go out to that restaurant and you take advantage of the fact that you're all at a restaurant and you start talking about board business, that's going to be problematic. You also should think about the optics of it. All of our board members are out to eat, right? I'm not saying you can't do it, but you got to think of the optics of it. I'd rather, I'd laugh with people, but I'm like, if you're going to go, to McDonald's and all sit there and eat, post the meeting at McDonald's and then you won't have the issue because people will find a way to complain if they can. Unilateral communications are fine. So if Jeff, Dipti sends an email to all of you to say, please make yourself available for July 13th at 5, that's fine. Even communication on that, it's fine because you're only talking about scheduling. You just can't take advantage of the fact that you're all in the same chain and talk about something that's business related. And then remember, even if it's not an illegal meeting, it's still subject to FOIA. It's a public record that if requested, you'd have to disclose. And so you would just want to be careful about what's in there.
So just, I just want to take this opportunity because every time we do this training, it comes up about a personal email address versus a specific Board of Ed email address. Because if you have one email address for both personal and Board of Ed stuff, and you get a FOIA request or there's litigation and your emails are subject to discovery, then you have to turn over all your personal emails for review to see if they contain any relevant information or something along those lines. So we've had that debate many times, and for whatever reason, years ago, we came down on the side that we're not going to have dedicated Board of Ed Cromwell email addresses, but if you wanted to have a specific, or set up a specific email address only for Board of Ed emails, you can do that. But if you wanted to comment on that issue.
So I would say, so not only would you have to hand them over, but the Freedom of Information Commission can subpoena your emails. And if they feel, and there's evidence that you're holding back from your personal email, they can subpoena your personal email if it's related to board business. So I always advise, as best practice, not a legal requirement, everyone should be using a Cromwell Board of Ed email. Because, scenario, many school districts are dealing with the changing of a mascot. It has generated a lot of. There have been email requests to certain districts. I want any and all emails between all of the Board of Education members, the superintendent of schools, the school administration for the last year. Everyone who sent a communication about a mascot for the last year. And guess what? We have to hand that over. It's quite the process because the school district has to first retrieve all the emails by plugging in search engines. But you then, Board of Education members, if you're using your Gmail account, you're going to have a very explicit obligation to go through all your Gmail, hand everything over. There also could be a litigation hold placed on your personal email to say you can't delete or destroy anything related to this, because if you do, that could be viewed as you are intentionally interfering with this process, particularly if we find ourselves in litigation over this or before the Freedom of Information Commission. So best practice would be that it's on the email, on the network server, so it makes it much easier to gather that information. But people cannot hide behind their Gmails or their Yahoos. And I've seen, and John, I saw you shaking your head. I've had FOIA subpoena Gmail accounts, Yahoo accounts of public officials. So to me, I would say best practice is you're using Cromwell. That just keeps it clean. You keep your separate business away from your personal business. If you are emailing a teacher about your child, use your Gmail account, right? Because that's one area where I'd say that's not board business. That's your personal business. Now you've kept those two separate. That would be my advice.
Are you saying that we should all have Cromwell ones that the district is giving us, like they do for staff?
Yeah, absolutely.
And
We've asked about this.
many times out of,
So can you tell Enzo that?
Yeah. Where did Enza go?
Eversource is here.
Oh, okay.
This has come up in the past.
Yeah, Lori, so you guys, you absolutely should have that. And that's pretty standard.
I use my Hotmail, so I mean, I don't want.
And I'm sure you don't want to be using your Yahoo or your Hotmail for this type of business.
That big of a deal.
It,
Based on what you're saying, it could be.
well, look, you guys got significant FOIA requests a couple of years ago, if you remember. Significant. And we had to ask board members to go back through their emails. I think there were a few that had to be asked. Maybe not all of you, but names had emerged as possibly having some information. And some board members.
Pretty good.
You what, John?
Mike Camilleri got mailed pretty good.
Yeah. So I think we just have to be very careful about that. And my advice and best practice would be you should be on the Cromwell district email. I don't see why that's a heavy lift in terms of them providing that to you.
Yeah, I just don't recall the reason for that, but I'd have to go back and look. But
Okay.
it's at the top of the list.
Okay. No, but Lori, thanks for bringing that up. And Jeff, you too. Those are great questions. Okay, so we defined a meeting. A meeting is very broad, right? Obviously, we're here at a meeting. It's properly posted. What does a meeting not include? Personnel search committee. So when you appointed Enza, did you appoint all of you to the personnel search committee?
Yes.
Great. Which means you could interview candidates, you could talk to candidates, you could talk to consultants and not have to post any of it, right? Because people like Enza, if they're not getting the job, they want to be able to protect their livelihoods and anonymity so it doesn't impact them elsewhere. So that's really the purpose of that. Any social meeting we talked about, look, you guys can be friends, just don't take advantage of the situation. If you all show up at the basketball game, Just don't take advantage of that and start talking about who you're supporting for chair, right? Negotiations, as we know, I think most of you have been involved in negotiations at some point or another. All of collective bargaining, by definition, falls under a non-meeting, which is actually a legal term. A caucus of a single political party. Now, people, this is an area where people violate this a lot. That absolutely means that I can only meet with Democrats or I can only meet with Republicans. I cannot bring in the town party chair to a single political party caucus because he or she is not on the Board of Education. So that's going to waive that ability to have that be a non-meeting. The other thing that people also get confused all the time is, well, I reviewed those documents in caucus, so they're not subject to FOIA. Absolutely not. Just because you reviewed a document that would otherwise be subject to FOIA in caucus doesn't mean that that actual documentation isn't then later subject to FOIA if it's requested. It just means that the contents of your discussion can happen in a non-meeting without you having to post it. So that happens a lot. So just be mindful of that.
See, we as Democrats can actually have a caucus and invite our political chair.
You can?
Of course. We don't have enough members to constitute a quorum.
Oh. Okay, I was going to say, that's creative, John. I like it. But just be careful that you're not deemed like a subcommittee or of anything, right? Because subcommittees also are subject to FOIA.
Right.
So even if there's just 2 or 3 of you, you have to be mindful of that. So Enza, one thing that we just confirmed.
That we're not gonna have power until 8:30? I just
Oh.
that.
So how are we out of power? Because everything else is working.
Generator.
Oh, the generator.
Generator kicked on.
So it won't, so we'll end before there's power.
I was like, and if
Yeah,
we bring-
absolutely we'll end before there's power. So Enza, one thing we talked about that's actually pretty important, and Jeff raised it and then Lori raised some really good questions about it, is my recommendation would always be that Board of Education members use Cromwell emails for board business,
Okay.
not their own personal emails. Really because of everything that I've seen when board members are subject to FOIA and their emails are subject to FOIA, it's really difficult for board members to have to go back through their personal emails. Not that this would ever happen here, but I've also had board members who have had their personal accounts subpoenaed by the Freedom of Information Commission because there was evidence to suggest they were hiding things or not being as forthcoming as they should be. This way we can avoid that. So I did say, though, if I'm contacting a teacher or a principal about my child, I should use my personal email for that because that's separate from board business. But best practice and what most places do is that you would have your own personal Cromwell email.
Would you like me to do that and set everyone up with them? Okay.
Yep.
Okay, on my list, and Rob won't let me forget.
Okay, so, I want to be mindful of time because I know we started at 6. Do you want me to just go through some scenarios that are helpful? Because I'm sure you're very familiar with regular, special, emergency.
Yeah, I think let's keep going. I think this is
Okay.
great. So, unless someone disagrees.
All right. I'll go very quick through some of
Whatever,
this.
We're juicing the generator.
Yeah, I'll go very quick. So we know we have our regular meetings, we have our special meetings, we have our emergency meetings. Our regular meetings, pretty much the annual schedule is filed with the town clerk by January 31st. We know our minutes have to be available for public inspection within 7 days of the meeting, even if they have not been formally approved. 24 hours in advance, the posting has to be there. The one big difference between a special meeting and a regular meeting is what?
Agenda.
And what about it?
On a special meeting, you can only talk about the items on the agenda. You can't amend the agenda like in a regular meeting.
Right.
Or you can add
But if today, let's say Selena said, I want to talk about a proposed turf field, could you do that here?
Yes.
Okay, and how would we do that? Right. Yep. And how many people do I need to vote on it?
To amend the agenda?
To amend and now include this new business item?
Is it a supermajority?
I need 2/3 of those present and voting.
What about, in the world of, weeks. I remember a couple years ago when we were going through that whole vet thing, and I was joining remotely. When I voted, it didn't count because I wasn't in the room. Like, is that
So just to,
change
we had a
because of COVID?
Yeah, that's a board issue, not a government issue, not a higher government issue.
Okay, so we made
We had a policy
Yeah.
that says if you participate electronically remotely, that you wouldn't be able to vote, but you can participate in the discussion, just couldn't vote.
But during
COVID, I
like,
think
when
there
John
was,
voted, it
Well, COVID, it was different,
there was an
right?
executive
So
order in
COVID, there was an
place.
executive order, but what you're talking about, exactly to Jeff's point, was a policy that you decided. Now, there are other boards of ed who have policies that say, if you're there and you're audible and people can hear you, you can vote just like any other member, even if you are remote. I don't know, did you update that policy?
not since
Is that still in
COVID,
place?
But that was.
So it's something you could
Yeah.
certainly look at because it makes a ton
I
of
mean,
sense.
I think it worked fine, during COVID, doing it remotely.
Right.
but we didn't really follow the policy then
Because there was an executive order that was in place. That
so
said,
is that not in place anymore?
I don't know if it expired. I don't.
Yeah. Well, all the executive order, most of them are still in effect through July 20th. But we're going to see a lot of changes, I think, in the coming weeks.
But John's here now, we're happy.
Love it.
He can hear us.
And, John, it is nice to see you in person, John. It's been a while.
I have to say that you guys were a lot more tolerant of my comments when I was remote. It may have had something to do with the mute.
Well, they could put you at, right. They could mute themselves.
You weren't.
Jessica, quick question.
Yeah, of course.
Right here.
Selena?
And you had said you can add a new business item to a regular
Yep.
meeting agenda. I thought the purpose of posting the meeting agenda was so that the public has the chance to look at what's on the agenda and then the chance to comment on it publicly if they want to at that meeting. You're saying any kind of random topic?
Only
can
at
be
regular
added?
meetings. So
Okay.
you're right. The FOIA says the agenda should be clear enough so that the public is fairly apprised of the business to be transacted. That's why it has to be a 2/3 vote, right? So that we can have kind of a check and balance of that, so that a 2/3 of those present and voting, not just a majority, right? Because then you can get into minority representation versus who has more of one political party to kind of control the agenda, right? But that absolutely is okay at a regular meeting. It is not okay at a special meeting. An emergency meeting is very different.
Okay, thanks.
All right, so we talked about that. All right, so let's do a scenario. A parent is all over social media after her daughter was suspended for insubordination 2 days before the prom. The parent calls you and every other board member with her concerns, complaining about the fact that her daughter has only one junior prom in her life and will not be able to wear the expensive dress she bought for the occasion. This is an actual scenario. This happened to me 2 years ago. In light of the pressing circumstances, you talk it over with a couple board members, and with the agreement of the chairperson, you decide by email to convene an emergency meeting for the next morning to review and possibly rescind the action by the administration. Is this legal? John, do you want a clicker? But I have extras.
I'm entrusting her.
You want extras? Or Jillian's your delegate? Okay. Rob, do you want a clicker? Okay. All right, good. Everyone got that right. Just an emergency meeting.
See, I can delegate the hell out of it.
People will always say to me, so I had people, even with COVID and the executive orders coming down, saying, it's an emergency meeting. We have to be able to meet right away. Really isn't. The only thing that I've ever seen upheld as an emergency meeting is what happened in Newtown, right? So because you have the ability to post for a special meeting within 24 hours. So in most cases, an emergency meeting is really not appropriate. So just be mindful of that. And if you do post an emergency meeting within 72 hours, you have to justify the reasons for doing it. And so sometimes it's too much of an onus or a burden on you. You're better off waiting the 24 hours. All right. Board member conduct. I know that we all get along very well in here, but there are some other places where there's some negative interactions between board members or sometimes between our superintendent and our board members. So we're going to talk a little bit about board conduct. What?
I'm glad you're using Mooney's example.
This is a Mooney example, absolutely. So board member malcontent had been causing issues for the Nutmeg board. During meetings, he would often verbally attack the motives of other members and staff, and it was suspected that he leaked information from executive session, which, by the way, we all know that that's absolutely not acceptable for board members to do. He would visit school buildings unannounced, demand to be able to visit classrooms to, quote, check on underperforming teachers. But the last straw for the board was when he voted to approve the new teacher's contract, even though his wife was a teacher in the district. In a special meeting where Mal was not in attendance, they voted 8-0 to oust him from the Nutmeg board. Just remember, just be prepared that the answers here are a little gray intentionally, so that it's not so obvious. Okay, so which statement is correct? A board member never can vote on a spouse's contract. B, the board member should not be serving on the board because his spouse is a district employee. C, the board's vote to remove the member from the board was invalid since the member was not in attendance. D, none of the above. So we can talk about that, Lori. So let's see what the voting is, and then we'll go through them each. John, do you want one? Let me get John a clicker. Where did my clickers go? Didn't I have extra ones? Oh. Here you go, John. All right, let's see. Okay, see, we purposefully. Okay. So let's go, Lori, with B. This is not a legal question. This is a policy question. And so there are some boards of ed that have very specific. Now, if you're a charter school, you're required to have a nepotism policy. That's statutory. Boards of ed are not required per se to have a nepotism policy, though it doesn't mean that you don't choose to do so. You can limit, or you probably have a policy, because most districts do, where they would say, Lindsay's spouse could work here, as long, of course, as Lindsay had no supervisory responsibilities. Lindsay didn't vote on the contract. So, you could be very specific on that policy, but it doesn't mean that your spouse can't work here.
They can vote on the contract. We actually went to court over that about 15 years ago.
Well, which is why the right answer is D, right?
That's the one I picked.
But
Julian's running for the
this is why, right. So this is why we throw, but A, if you have a, highly recommend to protect you, Lindsay, that you're not voting on the teacher's contract, because that is, let's say you're part of the teacher negotiations, then you vote on the teacher's contract and you're on Cromwell's insurance. Doesn't that look like a conflict of interest? I would be concerned that that would be an ethical issue for you. So I would say best practice, best policy is we don't allow that. You don't negotiate the teacher's contract. You don't vote on the teacher's contract. However, you can vote on the full budget, even though the biggest line item, one of the biggest line items is going to be the teacher's salaries. You absolutely have the right to vote on that. But I would stay away from you, and I don't even know if you have a spouse who works in the district. I'm just using you as an example. I would stay away from that kind of involvement. So you could have a spouse. You yourself cannot be a board member and work here. That's statutory. I have had cases where board members have applied to work here while they're still board members. What do we think about that?
You plan to
Well, I've had some say, well, I'm not going to resign until I know if I got the job or not. I would say resign, and then you can apply for the job. Because if you don't, now what does that look like if the superintendent hires that board member who has not yet resigned, right? So these are all appearances of impropriety. Even though I can't point to a statute, ethical issues we need to be very mindful of, right? Because it's going to look like we favored that person to get them the job. Okay. So the other thing that did not come up in the questions, but also if you remember in the scenario, they talked about voting Mal out 8-0 to oust him from the Nutmeg board because they were so fed up with his behavior. So do we have the legal right to do that? So let's say I'm fed up with Lindsay. We want to vote her off the board. Do you have the right as an entity to do that? You don't. No. She's an elected official, right? I mean, I I had a town council person who literally fled the country and lived in Jamaica for about 3 years and wouldn't resign. And we had to advise the town council, you cannot vote him off the board. I don't think it was 3 years. I think it was probably a year.
About 9 months.
Yeah. It was, so I exaggerated a little bit with 3 years, but it was a long time. And he wasn't showing up to anything. And you would think that's, and he wasn't even technically, but he still had a residence in town. So you couldn't say his appointment or election was null and void because he's still in the town. But we couldn't vote him off. We had to wait till we got his resignation. So you're never going to be in a position to do that. That doesn't mean that you can't censure a board member for behaving very badly. It doesn't mean that you can't meet an executive session to discuss that board member's performance that you have concerns with. But that board member can attend that executive session. They can't tell you can't tell them you're not attending, like we could if we wanted to discuss the performance of the superintendent of schools. She'd have the right to have it held in open session, which we would have to do, but she couldn't demand to be at that executive session. You as a board member can absolutely demand to be at the executive session because you don't have the authority to box that member out of the executive session. The board chair does have the ability to say, look, your behavior at negotiations is unacceptable. You're belligerent, you're rude to our teachers or our custodians, and I'm taking you off the committee. You have every right to do that. You can strip them of all committees, but you can't strip them of the right to be a board member. You can also censure them through Robert's rules. That's a long process, but that is something. But ultimately, you spend a lot of time and money to issue a public reprimand. But in some cases, it's warranted. Okay, so we talked a little bit about this, right? So you cannot be employed by the school district. We have no statutory provision that says a relative can't be employed. Your actions are governed by board policies or ethics provisions in local charters. So I don't know Cromwell's charter off the top of my head, but most charters incorporate a code of ethics that is applicable to all commissioners, including board commissioners. So, it might be worthwhile if you ever want to look at what the charter talks about with respect to a code of ethics and the responsibilities that you have as Board of Education members to the town that you're serving. The other thing too is, I don't know if this ever comes up for you. I know you don't have a lot of disciplinary proceedings here, but let's say you came to a disciplinary proceeding, and I think this actually happened once here. You need 3 affirmative votes of a board member to expel a student. We had 5 of you here. We typically don't give the student's name in advance because we want to protect the confidentiality of the process. 5 of you came, and 1 of you recognized the student and said, I don't think I can be impartial because of the relationship that I have with the family, so I'm going to recuse myself. We can't force someone to recuse themselves, but it's really up to the individual board member to, kind of have a moral compass about it. Should I be recusing myself? And my train of thought on that is always, Dipti, if you don't think you can be impartial because of your relationship either with the teacher, the employee, or the student, you should recuse yourself. All right. Let's talk a little bit about executive session. So here's a scenario. Ooh, this is another Tom Mooney scenario. John. Okay, so Tom Mooney is, he's the
guru
of school law. He's the chair of our practice group. He wrote the treatise that all education,
The Bible.
the blue book that everyone has. So he actually wrote the book.
Bible is not the appropriate
No,
word.
no, I mean, I read that.
Yeah.
It's in my hands all the time.
Yeah, right. So he works at our firm, wrote a book. He's very well known. And so some of these scenarios I stole from him. But some of the earlier ones are ones that actually I went through. Okay, the Nutmeg Board was in a special budget meeting when it learned of dire economic news that meant significant staffing cuts were necessary. Knowing that the board would need to discuss and decide the elimination of specific positions and not wishing to needlessly distress or excite its employees, the chair added an executive session item to the agenda to discuss, quote, personnel matters. With a 5-3 vote, the board entered executive session. After an hour of discussion, the board members agreed without a vote to direct the superintendent to cut 10 staff positions. Okay, which statement is incorrect? A, the board's agenda must state that the board will go into executive session. B, a vote to go into executive session must be by 2/3. C, stating that the reason for executive session was for personnel reasons is insufficient. Or D, the board cannot add an item to the agenda during a special meeting of the board. So which statement is incorrect? Throwing for your loop, Jillian. Throwing you for your loop. Everyone vote? Okay. Okay, anyone want to share? Jeff, what'd you go with?
I said A.
Yeah, what'd you say, Lori?
I said B. Why does it have, I thought it was just, it has to be 2/3?
Yep, so an executive session has to be done by 2/3. Now, again, of those present and voting, right? So if there's, 6 of you, you need 2/3 of 6. If there's 9 of you, you need 2/3 of 9. Stating that the reason for executive session was for personnel reasons is insufficient. So 11% said that was incorrect. Why do we think that's incorrect?
I just felt like the other three were correct, so.
Okay.
Discussing matters related to personnel is a reason for allowing executive session under this.
But not if you just say personnel reasons. So there's actually very specific case law that says if you just put personnel reasons, because the actual provision is discussion concerning the performance or employment of a public official. Evaluation, performance, employment. So if I just say personnel reasons in my scenario, I don't have the right to discuss if I want to cut positions. That's not specific to anyone. That's not specific to Jeff Matrullo. That's specific to I'm looking at positions, not people, and I need to make that cut. So that was an illegal executive session because it wasn't specific to the evaluation, performance, or employment of those individuals. It was specific to whether you could afford to keep those positions, which is not a reason for executive session. There's also, if you just say attorney-client communication, that's not an appropriate executive session. There was case law recently from FOIA that says you have to describe briefly what's in that attorney-client communication. So every time I've ever sent you one, you've seen on the agenda item, I don't just say discussion concerning an attorney-client communication. I say discussion concerning an attorney-client communication related to the turf field or related to a school mascot naming issue. I always give a brief descript or else you're in violation of FOIA.
So Jessica, on
Yeah.
C, going back to personnel reasons, and when you say going into executive session for purpose of discussing performance or whatever the words are, should you or should you not name a specific person? I assume you shouldn't.
Well, you don't name the person, but just think about it. This is why this is so wrongly applied everywhere, because people are going into executive session for personnel reasons all the time, but I just told you how limited it is. So you're probably violating it if you actually are, because the only person you're really discussing their performance of or the employment contract is your superintendent of schools. Now, you might be discussing the employment contract of the business manager, of the HR director, because they're not affiliated. I wouldn't put discussion concerning the employment contract of Michelle DeMauro, but I would put discussion concerning the employment contract of the HR director. You might be discussing a request for an extended leave of absence that contractually has to come before the board. You wouldn't name the teacher, but you would say discussion concerning, the employment request for leave of absence made by a teacher, something like that, because you're discussing his or her employment and the request for the extended leave of absence. Now, If you are discussing, let's say, the superintendent's contract, she has the right to have that held in open session. So that person needs to be notified. So in the Michelle DeMauro example, she would have to be notified at least 48 hours in advance that you're discussing that. She can say to you, the discussion has to be held in open session. You have to adhere to that request. But if she declines the open session, she can't demand to be in your executive session.
She declined, and I took care of it. We're good for tonight.
So again,
It's actually on the agenda, which is
Oh.
it's funny. It's actually real.
yeah. Well, I think that probably, subconsciously came up. Yeah.
Just quickly,
Yeah.
if it's a legal matter and you're coming to give the board an update about a legal matter which the district is being sued.
Well, that's a pending claim or pending litigation, which is a separate exception, which we would never do under personnel reasons. Right?
It's something completely.
So we'd either do an attorney-client communication, but it would be to discuss a CHRO lawsuit. I'd have to at least give a description of the CHRO lawsuit. Or it's discussion concerning a pending claim. I can't just say pending claim. I'd have to reference something so that at least the public had some indication of what pending claim I was discussing. But it actually has to be a pending claim. It can't be the threat of legal action. You actually have to have been served.
Got it. Okay. I just want to make sure we remember.
Yeah, so we basically went through all of this. So we talked about the, and so you were a step ahead, and secure. No, it's great. Collective bargaining strategy. We can do that through a non-document or a non-meeting, or if you have actual records of strategy, you can discuss that in executive session as long as you're specifically discussing records of strategy. Otherwise, you would hold a non-meeting to discuss it and then come back to open session to vote on it. The security devices in real estate is very interesting. And actually, this was passed after Newtown, which blows my mind, because I would have thought that after Newtown, they would have said, well, no one should have access to schools' security information, like where we keep the cameras, where we keep certain safety equipment, things of that nature. But instead, they said, you first, before you can deny someone asking for that information, you actually have to go to the agency. I think their acronym is DESP. They're like the Department of Emergency Protection or something like that, and ask their permission to say, we think this would be detrimental to the safety of our students in our communities, so we don't want to hand this over. And then you need permission from them before you cannot hand it over, which I just find unbelievable, because I would think it would be the opposite based on what we've experienced with school safety issues. So that's interesting. So just in closing on executive session, it never has to be an agenda item. You legally don't have to put, even though, Selena, to your point, we do have to fairly apprise our community of what we're discussing. In executive session, at a regular meeting, you can decide, I want to have an executive session on this. And if it's appropriate, you can add it for 2/3, and then you can go into executive session for 2/3. I always recommend, though, as a courtesy, you say, proposed for executive session, anticipated executive session, so that Jillian then can read the agenda and say, okay, they're probably going to go in executive session now. I probably know that that's my time where I need to leave, and then I can come back when we go back to the public meeting. All right, Jeff, let me know how you're feeling about time.
I was just looking.
Do you want to go through? Yeah, do you guys want to just, if you have any questions or anything you want me to cover?
Selena had a question, I think.
Sure.
Can you go back really quickly?
Yeah.
When you were just talking about adding the executive session onto a special meeting?
No, not a special meeting. Only a regular meeting.
When we had those 4 options, D was that you could add it to a special meeting.
Because that's incorrect,
Oh, okay.
right? So we revert, yeah.
Just to be clear, C was the right answer.
No, so let's go back. Let's go back to the scenario. No, it's, which statement is incorrect? Let's see. No. C is right, because that's correct. Stating that the reason for executive session was for personnel reasons is insufficient. That's correct. A is incorrect.
A
because you don't legally have to put executive session on the agenda.
But it doesn't have to be in
Because you might not know it. That's exactly right, Lori, too. If I put executive session 4,
Oh, I see.
we've preordained, it means that, like, I already know I've talked to all of you that you're willing to do an executive session. That's what the perception might be. And that's an illegal discussion, right? So that's why it's proposed for or anticipated, because you know you have the right to do it. You just don't know what your votes are, whether you're going to have the 2/3 of those present voting. Anything else, Jeff?
Maybe just
You let me know. What
the-
slide number?
there was
Page number should be down at the bottom somewhere.
it
On
was
the left.
conduct during meetings. Just
Yeah, what slide?
Past it. Is that what it was? Best practices, I think it was 58.
58. All right, let's jump ahead.
It's the high level stuff.
Trying to get there. I am.
Yeah, they weren't very nice.
I'm so sorry. I'm so embarrassed. I'm so sorry about that. That's terrible. My sincere apologies. And you know what, John? If you hadn't pointed it out, I don't know if anyone else would have seen it. But I appreciate it.
But you're counting on me for typos. The apocalypse is near.
Okay, so what do you want to talk about here?
Just if you want to hit the highlights.
Yeah, absolutely. So what should you not be doing as a board member, right? So this might seem self-explanatory, but again, I can't tell you how much dysfunction I've seen in boardrooms. You do not talk about administrative matters, right? That's, again, just not your purview. It doesn't mean your superintendent of schools can't update you on administrative matters or share information with you on the aggregate, but that is not within your purview. We have to trust our superintendent of schools to do that work. You never single out or criticize individual employees. Again, I told you the case I had where at a subcommittee meeting, a Board of Education member was belligerent and attacked administrators for being, in his mind, not prepared for the meeting. They filed an unfair labor practice against him. He had an ethics complaint pending after it. It incurred significant time and energy of the board. Remember, too, as volunteers, you're technically indemnified if a claim is brought against you, because the assumption is you've acted within the scope and responsibilities of your duties. And so if you act in good faith, you're going to be indemnified if you, the Board of Ed, are sued. If you are negligent and don't act in good faith, you can be held personally liable for your conduct. So then in that situation, we got into the argument of whether the board was going to indemnify him or not based on his actions. Again, it just became very difficult, time-consuming, very expensive process. Don't debate with the public. I think we know that, right? I think you guys are very respectful. I saw how you did the public comment here. Jillian was excellent in her presentation, and you said, thank you very much. We will take that under advisement. Don't tolerate rude or inappropriate behavior. So we should expect professional decorum from all of us, right? We should expect that even if we don't agree with our superintendent or if we don't agree with Dipty's opinion, that we express it in a calm, professional, civil demeanor, right? Again, I know that seems self-explanatory. And then, if it is becoming escalated, then Jeff, that would be your responsibility to step in and say, point of order here. We're not going to tolerate this, right? Don't discuss or spend time on trivia or unessential matters. And don't make it personal. So again, Board of Education members, you have every right to be a parent. You have every right to be a citizen, a community member. But just remember, when you're here serving in your capacity as a board member. And so it's not really appropriate to bring your own personal agenda items to the board, right? We need to think more broadly, think more globally, that you're here to represent a constituency and a base and not here to make things, better for your personal situation. So we just need to be mindful of those things. Again, everyone here is so lovely. I've always enjoyed working here. I don't think that you have the issues that other places do. But these are just general guidelines that board members should be mindful of.
May I ask a question?
Sure.
Please.
How do you intend to deal with if, God forbid it ever happened, there was some unruly, crazy person such as myself here? No, but really, if there was, you see it on the news right now, right? With
Yep.
everything going on with the political climate and, our town is so wonderful and we're all quiet and calm and there's nobody here, but if something did come up,
So
like you said, don't debate with the public, don't be rude, but, you see it on the news and there's people just being dragged off the stage. People are yelling.
yeah, I mean, honestly, I would, let's say if you feel something like that might happen, so let's say you've had a member from the public or a member of the community who has made you feel unsafe or threatened you, I've advised boards to have police presence at meetings. It's gotten to that point where in some places it's gotten scary. There is threatening behavior. I wouldn't advocate for you holding meetings without having a police presence. If you don't expect it and it happens, Jeff, you would first interject and say, look, we expect that you're going to have a professional civil demeanor. I know you make those opening comments with the public comment as it is. But then if they don't listen to you and they become belligerent, I would call the police. You have every right to do that. Hopefully it doesn't come to that, but that's what I would do in that scenario.
I'd like y'all to be safe.
Yeah. No, absolutely.
You seem like
And
decent enough
I think, Enza, you've been in situations where the police presence has been necessary.
100, in the past district.
Yeah.
I worked in 100% of the time there was a police officer present at board meeting. Yes.
Yeah, and there are some places just by every meeting, their SRO officer is there.
Whatever obviously is, we could have that happen. There is a cost to the district. If you would like that, you discuss it and let me know what you would like me to do. But I have experienced some scary situations, and luckily that hasn't happened here. It's unruly sometimes, but nothing where any of us felt like our life was in danger. But there were times when we did conceive hiding underneath things, and no one should feel that way, especially when you're volunteering. No one should ever feel that way. So you let me know. But there is a cost.
Any other questions or any other slides you want me to go over? Yes, Lena.
I just had to look this one up because I knew I read it. And thank you, Lindsay, for being able to open it on your phone. But the removal from office, going back to that, our bylaws do provide for that. So I don't know if that's something we need to update.
What does it say?
Ours say removal from office. Any board officer may be removed from a position of a board officer.
Officer.
Yeah, that's an officer. So
different?
Jeff has the ability to say, you're no longer vice chair. You're no longer on
like
this
a position
committee.
within the board. Got
Yes.
It. Okay.
So you absolutely, if you felt this vice chair or this treasurer, they were not acting appropriately, you have the board have the ability to address that.
Okay.
You don't have the ability to say you can no longer serve on the board.
That doesn't mean, Selena, that you could beg Jeff for pardon.
Darn it.
No letter. Please.
I think this is great. I wish I had it when I started. Can we give these to Board of Ed members?
Let me just put the W in slide 4, and then yes, you can.
Yeah, no, absolutely, absolutely. And I know we did this some years ago. I guess it hasn't been in the past recently, but I remember Tom coming in, and it's always been very good. So I wish we could have done it, like I said, the past couple years, but So thank you so much.
Yeah, I'm happy. And there's a lot we didn't cover, but feel free to, in your spare time that you probably don't have, and if I can answer any other questions, just let me know.
So we do have 2 members who aren't here. If we could take materials for them to.
Can I
distribute to them?
fix
You can
that
fix
slide and send it
You can fix that.
to Enza
Yes.
to send
Yes.
to them? Thank you. And my sincere apologies.
I have one more question.
Oh, there's just, Selena has one other.
Sorry.
Sure, of course.
Dr. Macri, I had sent you that email earlier today.
With me in case you want it.
So I printed out, I know that you provided two of our, one says board-related responsibilities and one says limits of the authority, but then there was another 9012A that says legal responsibilities of the Board of Education. And there was just a lot more on there than I expected. So, for instance,
You want to show
do you want-
that to Jess?
do you want to see a copy?
Yeah,
of
sure.
it?
Do you have a copy of
I
it?
just
Yeah.
circled some of the ones that seemed like weren't listed as our role, but are in there. Or maybe I'm misunderstanding them.
Yeah. So again, so we don't have the page when this was adopted. So some of this I'm not concerned about. So for instance, like number 5, when it says determine the number, classification, duties, and remuneration of employees, you are doing that through collective bargaining, right? It is the Board of Education who ultimately decides whether you're going to have an HR director. It might be that the superintendent brings that as a recommendation, but you're going to vote on that. You're going to vote as best practice what the pay increases would be for any non-affiliated staff. So that to me is encompassed in number 3, which you've circled. And you can't pass collective bargaining agreement has to be voted on by you. Then for certified staff, it's sent to the town and they have the ability to reject that. When it says establish the policy for employment, promotion, and dismissal in accordance with state statutes, again, you're negotiating the termination provisions in non-certified contracts. And you also negotiate the business contracts that you have with your HR, your superintendent. So I'm okay with that. And then with state statute, the certified staff, you don't have any say in that. That's all governed by 10151. To provide for the appraisal of the performance of personnel, I think that probably should be updated because again, the only person you're evaluating
Dr. Macri.
is Dr. Macri. And for certified staff, all of that is now, because this was probably adopted before they did the education reform, where we did an overhaul of the teacher evaluation system, which you can't legally circumvent. Now, you can be, through the PDAC committee, you can decide what some of that's going to look like. But again, that's something that you're really going to rely on the recommendation of your superintendent. You're probably not going to get too involved in the weeds on that.
And we do have a board rep on our feedback.
And curriculum, you actually do have some significant oversight over curriculum, though typically by practice that is delegated to the educators who have that expertise. But I assume that you vote on curriculum changes. Major ones, exactly. So that's pretty standard. So some of that, I think it probably does need updating, Selena, but some of this I'm not overly concerned of because it's mostly collective bargaining. I would take out the appraisal of the performance of personnel because with education reform, I just don't.
Jessica, can I just, because
Yeah,
when
sure.
we talk about curriculum and instruction, and since it is my love, we would vote on clearly things like adopting the state standards, which are statute, Common Core, all of that. As far as programmatically, like if we are purchasing a program to support a specific curriculum that's research-based and so on, you wouldn't vote on that because
No, but it'd
you
be part of
voted
your
on the budget.
final budget.
Right.
Exactly.
You voted
So
on the
exactly.
Right.
So only major
we'd have
changes.
meetings every day
Right.
if I had you here. You wouldn't want that.
So the major ones, like Jeff clarified, all the major things you're voting on. All the other things that you're making recommendations in your budget, the Board of Ed can absolutely say, well, hey, Enza, I see that you've set aside $30,000 for this program. What's the benefit of this program? And they would rely on your expertise for that.
Yes, yeah, and anything, big that we would purchase and bring to you.
Right. And I do think it's very important, I think you do it here, that any non-affiliated contract is brought before the board. I think I know that that's been happening under Dr. Macri's tenure and maybe wasn't always happening.
What do you mean as far as?
So like you're voting on the HR contract tonight.
Oh, yeah,
You're
yes.
voting on, I don't know that was always happening. So I think that's, again, going forward, we want a record of all of that.
Okay.
So that the board is informed of that and that you can say, no, board, see, you did vote to approve the 2% here. for the HR director. You did vote on this contract for the business manager, things like that.
Oh, okay, no, so absolutely, no, we are not. As far as the HR, because there's a direct line to, God, I'm trying to not break violate any laws here. That's the only one that is brought forward. I negotiate and I'm consistent
Okay.
across the board with the other directors, but I negotiate with them based on you rewrote all the contracts for us.
Right, but you
And-
don't put it on the consent agenda or have
No.
the board approve them?
No.
Yeah,
No,
I
I
just-
never have. If
I would just say, honestly, I think you have the authority to negotiate that. They absolutely can do that. I just think I would at least have it brought on the consent agenda. I just think I've seen
so, anyone who is not part of a bargaining unit.
the
Or
big
only
positions.
directors, just the big, not the little.
The big
one.
ones, right? So I think you can certainly delegate to your superintendent of schools to say, you know, some of the, you know, non-affiliated positions that don't have significant decision-making authority.
Okay,
But I want to protect you in that instance too,
right.
so that your board, and I've seen this happen, doesn't say, well, I didn't authorize you to give this person 3%.
Yeah.
I didn't authorize 3% to that. I always want you to be able to say, nope, I brought it to you and I have a record of it.
Okay, yeah, I've never done that before in either district, so,
And again, that's not a legal requirement.
Okay.
That's just if you guys came to me and said, what would be the best practice for something like that? I think that protects both the superintendent and the board, that everyone's just on the same page and there's been transparency on it. That's all.
in the consent agenda.
You do it on the consent agenda, right? So it, you know, you'd see the contract. So
Yep.
you'd see that I would notify them of the increases. Sometimes what people do is they have, you know, in executive session, you could be discussing the contract
Yep.
of the HR director. And in that executive session, they can authorize you to give her, let's say, a 2% general wage increase. And then later at the next meeting, you'd put it on the consent agenda, knowing that you had the authority to do that.
Okay.
So that authorization can happen in executive session, it doesn't have to be a vote.
Well, you can, when you're voting on the contract later in the consent agenda, you can have an understanding without voting. She makes the recommendation and you can have that understanding that, you know, I think across the board, we could support a 2%. Then it would still come to you later once the contract was ready for you to vote on it. Oh, you don't have a consent agenda. Well, you can just put it on as an action item.
We could add if,
You can add a consent
Yeah, we
agenda. That normally expedites meetings, so, yeah.
it's so great.
Let's look into
I
that.
love it. It's
Yeah,
beautiful.
right.
Knows we'd hate to get out of here early.
It's a beautiful thing. I was very sad when I saw that Cromwell didn't do it.
Do it. I didn't know about it. I didn't know about it until 10 seconds
Oh,
ago.
I'm sorry, and I didn't bring it up to you because I just thought Cromwell decided not to.
Can you explain consent agenda?
We'll have to go through that. We can do it later.
I could explain it.
Do you want to explain the consent agenda in
Well,
2 minutes?
consent agenda would just be items where you have a group of items that rather getting into the nitty gritty, in the consent agenda, it might just be approval of this contract, approval of the vendor contract, approval of the IT contract. You know what you're voting on, but you're not going through each item separately. It's all grouped together, and in one full swoop, you're voting to approve what's on the consent agenda.
So there's no discussion or debate or anything?
No.
That happened ahead of time? Or if there's any
It
questions?
can, right? Or, you know, sometimes the consent agenda are so I don't know, again, every board is different, but let's say you decide that you hire teachers or you accept resignations. All of that's going to be on the consent agenda because you're not going to go and talk about every single hire. You're not going to talk about every single resignation. In one full swoop, you can accept the hiring of 6 new special ed teachers, accept the resignations of 2 special education teachers without having 8 different items. It's
So-
one full swoop as a consent agenda.
So technically, what Cromwell does, I'm used to both. We have a personnel report that says this, resigned, retired, whatever. This person has been hired, whatever, and that is made but no, it's, I guess it really is a consent agenda without us saying it is a consent.
But are they
so I
voting
should
on
add
it?
that. No.
Right, but
It's
you might
information.
have an understanding or a policy here, because again, it's not a legal
look.
question, it's a business judgment of do you, Board of Ed, want to approve, and when I say approve, I don't mean get into the weeds of it. I just mean having a record at a meeting that you approved accepting these resignations and approved these hires. Now, you don't have to do that. You can delegate that to your superintendent. It sounds like she keeps you apprised. I'm more talking about where I've seen the relationships really deteriorate. And I've had situations where they have said to the superintendent when the relationship soured, and I don't expect that here, I never authorized the 2% for that contract. I didn't authorize this 3%. And so you always want a record. Remember, board of members change. So this board might say, we absolutely gave Enza the authority, but in a year you could be looking at a different composition of members who say, we never approved that. So that's why it's just best practice, the transparency of it, but it's not a legal requirement.
Okay, any other questions for Jess? Well, I think you heard positive feedback here. I think everybody benefited from this, so.
All right, well,
excellent
thank you
job.
guys so much. It's always a pleasure to see you.
Thank you.
You, John.
She got you back. Yeah, I think you already know, but working with a lot of attorneys, we are very lucky. We have a very good one who knows what she's doing, thank God.
And we'll have you back more regularly now.
Yeah, exactly. It's great. Thank you, Jessica.
Oh, yes, gotta collect your clickers.
Why, we can keep them and give them to our students. I'm only kidding you.
No, I'll get like charged.
Really?
Yes.
Oh my God. Yeah, I know they are. We buy them too. They're a fortune. Yeah. The kids love them.
I'm sure.
Because
Make sure you get them all back.
they can answer, you can answer without anybody knowing the answer.
Excellent. Okay, so that was excellent. Thank you. Next, comments, updates, and announcements from board members and administrators. We'll start with Mr. Flanders. Alessandra? Lindsay? Lori? Dr. Macri? Selena? Jen? Dipti? All right. Next, is there a motion to go into executive session? Okay. For purpose of discussing superintendent's evaluation, self-assessment, and human resource director's contract, possible action regarding human resource director's contract. Motion by John. Is there a second? Is there a second? Second by Lori. Any comments or questions? And we'll also invite Dr. Macri in for that discussion. Hearing none. All in favor? Aye. Opposed? Abstentions? So the motion carries unanimously, and we'll go into executive session at 7:45, inviting Dr. Macri. Yes, so we'll declare ourselves back in executive session. I can't see what that clock says. 8:51. Okay, is there a motion by Mr. Flanders? Is there a second?
Wait. Motion to come out of executive session made by John, right?
Well, we just declare ourselves back in, yeah. But there's a
Written
motion,
this way on here.
yeah, there's a motion by John to accept the HR's contract. And second by Lindsay. Any comments or questions? Hearing none. All in favor? Aye. Opposed? Abstentions? Motion carries unanimously. Is there a motion to adjourn? By John. Is there a second? Second by Jen. Comments or questions? Hearing none. All in favor? Aye. Opposed? Abstentions? Motion carries unanimously. We are adjourned.